Content warning, this episode contains extensive discussion of child sexual abuse materials and other crimes against children.
As we all know, back in April, Kegan Kline pled guilty to 25 counts, mostly related to child sexual abuse materials, and he's scheduled to be sentenced on those counts next week as we speak. There's been a lot of interest and curiosity about what kind of sentence he can possibly expect. Recently, one of the prosecutors working on the case, Jennifer Kiefer, filed a brief with the court outlining how the prosecution sees the possible range of sentences Kegan could receive. So we would like to discuss that, get into the weeds a bit, and try to explain how things look at this point, at least from the prosecution side of things.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
We first connected while looking into the Burger Chef murders, an Indiana cold case. Together, we built a spreadsheet documenting hundreds of cases of restaurant-related homicides. That original spreadsheet gave way to our podcast, The Murder Sheet.
Now we maintain that same research-centric, investigative approach as we look into all sorts of homicides, including unsolved cases, historical crimes, and, of course, restaurant murders.
We don't just chat about the headlines. Our podcast is a platform for our journalism. The Murder Sheet focuses on investigative reporting, thoughtful analysis, thorough research, and in-depth interviews.
We're The Murder Sheet.
And this is The Delphi Murders, a preview from the prosecution on Kegan Kline's sentencing.
Up to this point, I think the main thing that people have been curious about in terms of sentencing is whether or not the sentences that Kegan Kline could expect to receive on each count would run consecutively or concurrently.
What do those things mean?
It's a bit confusing because they're words that sound similar and even have the first three letters are the same. When you have sentences that run concurrently, that means they run at the same time. Let's say I get 2 sentences each for 1 year. If those sentences run concurrently, I can serve both of those sentences in 12 months and I'm done. But if those sentences run consecutively, that means I have to serve 12 months for my first count, and then only after I complete that sentence do I start serving my sentence for the next count. So in other words, 2 one-year sentences, depending on whether it's consecutively or concurrently, could actually amount to 1 year served or 2 years served.
So concurrent generally equals good for the defendant, and consecutive generally equals bad for the defendant, assuming they don't want to be in prison.
Yes, that's a good way of looking at it. That's one of the issues that's been most under discussion. Prosecutor Kiefer, who wrote this brief, makes it clear that she thinks that she believes Judge Spahr has a lot of discretion there as to whether to impose the sentences consecutively or concurrently.
So, but to boil it down, is it fair to say that the prosecution in Miami County, Indiana, wants Kegan Kline to receive a longer sentence? And that's what they're aiming for with this filing?
Yeah, basically, the prosecution wants him to be in prison for as long as they believe the law allows. So the brief that Prosecutor Kiefer wrote is basically an argument for here's why we think you can sentence him for as long as possible. Now, either in the courtroom or before the courtroom in a brief or both, defense attorney Andrew Ackey is likely to come up with arguments on the opposite point of view, basically saying here's why you can't or here's why you shouldn't sentence Kegan for a long time. Here's why you have to sentence him for as brief a time as possible. And that's because defense attorney Ackey, his job is to represent the interests of Kegan Kline.
And it's in Kegan Kline's interest to go to prison for as short a time as possible.
Exactly.
So these two opposing sides are going to be basically making a pitch to the judge, not in emotional terms, not in a Kegan is bad because he did these crimes and therefore should be away longer. It's going to be mostly in legal terms of what the law means, what the law can allow the judge to do. Is that fair to say?
That's very fair to say.
So while the idea of child's sexual abuse materials is frankly appalling and disgusting to most of us listening, it's one of those things that the prosecution can't just get out there and say, people are horrified by this sort of thing and we must throw the book at it, and they have to be arguing within the law. Yes.
Both sides have the same playbook, which is the code of the state of Indiana. And the code is the legislation written by the legislature outlining what exactly the range of possible outcomes can be. And that code is often revised or changed as times change.
Now, Judge Spahr himself may have some discretion within those bounds, but I think we've talked a bit about this in the past. He's still restricted by that code. He can't just say 100 years because I think, that's what I think would be fair. It has to be within the code.
Yes. A judge just can't say, well, I don't like that shirt you're wearing today, so I'm going to add 20 years to your sentence. A judge also, when they sentence someone, is supposed to identify both mitigating and aggravating factors.
What do those mean?
So a mitigating factor is when you say, this person did commit this act, but here are some reasons that make it maybe a little bit less severe. I'm going to throw out an extreme example here. Let's say a woman commits robbery, and she's obviously guilty of it, but she committed the robbery to steal some milk for her baby. That would be a mitigating factor. She did the act, but here's why she did it. Maybe this will make us think a little bit better of her.
She wasn't stealing the milk to further some sort of milk-stealing conspiracy to get rich. She was trying to feed her child, so therefore we can all understand that a bit better, and perhaps she was desperate, and perhaps if she was in a better situation, she wouldn't do it again.
Yeah, that would be hypothetically a mitigating factor. Now, an aggravating factor would be something like, yes, this person is guilty, and look, here's something that makes it even worse than we might think, or realize this is an especially heinous act. Here's something that makes it worse. Let's go back to the example of the woman stealing the milk. Let's say when she steals the milk, the cashier goes to stop her, and she pulls a gun, points at the cashier's head, and threatens to kill him, and the cashier is in fear of his life. That would be an aggravating factor.
I've read a couple of briefs about cases in my time where it's a murder case, and the victim is believed to have suffered unduly, or it was just a very cruel death, or there was a lot of fear in advance of the death, and the prosecution has argued that those can be aggravating factors. So it's not just like, I went to rob these people and my gun kind of went off and it just got out of hand and it was over very quickly. It's like, I held these people hostage for hours and tortured them and then I murdered them. So it's just basically like, how can we make this even worse from the prosecution standpoint? So I imagine that mitigating and aggravating are just kind of methods for a judge to kind of influence their decision when it comes down to handing out a sentence.
And it's important for a judge to talk about those things and identify them in the court record, because these things are always looked at and examined after the fact. And you want people later down the line who are trying to figure out, was this sentence fair? Was this sentence unfair? You want them to be able to understand what the judge was thinking. You don't want the judge to just say, oh, I sentence you to the maximum.
Because I think you're a jerk.
You want the judge to say, I sentence you to the maximum because I identify these aggravating factors. Or I sentence you to something close to the minimum because I identify these mitigating factors.
So basically, it's like, for all our teachers in the audience, it's, wanting your students to show their work. So you can see how they arrived at the answer to a problem, as opposed to just kind of jotting something down and maybe assuming, how did they get this? Or I can't even understand this.
It's very important for the judges basically to show their work. Last fall, you and I attended a sentencing of a murder case.
Yes.
And the judge in that case went into great detail about everything he considered.
I believe in that case, it was the murder of Amanda Blackburn and her unborn child. And that in that situation, I'm paraphrasing, but I believe the judge, and we can link to this episode in our show notes, but I believe the judge talked a bit about the convicted killer, or one of the convicted killers. There was a group of men, essentially like had a pretty rough upbringing. There was potential physical abuse there. So something like that would be a mitigating factor, because you might say, well, this person comes from a violent situation that shaped them into the person they are today. That doesn't mean that they're not a killer. That doesn't mean they didn't do this. But it does mean that had, an impact and maybe shaped their worldview and shaped the way they do things in a way that maybe wouldn't have otherwise. And in addition to that, and it's like a learned behavior, the violence. And in addition, but at the same time, I think he also noted the cruelty, murdering this pregnant woman. She's in fear. She's being robbed. It ends with, a heinous killing, I think. So those were kind of the sort of things that get thrown around in a situation where those are being weighed.
Exactly. Now, when you look at the statutes in Indiana, there are some regulations on consecutive and concurrent sentences. Basically, there are caps on the amount of time a person can serve if they are found guilty of a number of charges related to an episode of crime.
Why is that?
Basically, that would be to discourage prosecutors from overcharging a person. Let's say I walk down to the Walmart and I shoplift. I steal 3 boxes of cereal, 2 bottles of medicine, 5 bottles of milk, and so on. And then let's say the prosecutor then decides to charge me separately for each count. In other words, I'm going to charge you 1 count for stealing this box of cereal, another count for stealing this box of cereal, another count for stealing this box of cereal. I could be looking at like a dozen counts for 1 episode of shoplifting. And so the legislature decided in those sorts of cases, it should be capped. You should basically be limited to how many years you can spend in prison based on charges coming from the same episode of crime.
Because in most cases, that would be an abuse of prosecutorial power to send someone away for decades for a shoplifting incident. You'd be like Kevin Valjean or something. Prosecutor Javert. Yeah. So it makes sense. I mean,
so it makes sense. Now, what's interesting and also frustrating is that these caps don't apply to crimes of violence. And not too long ago, the Indiana legislature added to the list of crimes of violence child exploitation.
Which makes sense because it's a sexually violent act against underage children.
So that would mean, since Kegan Kline is charged with child exploitation, he would not be subject to those caps. But wait a minute. This new definition placing child exploitation as a crime of violence went into effect about 2 months after Kegan Kline committed his acts. So that means that new definition does not apply to Kegan Kline.
Wow.
Some people, I'm sure, are going to find that very, very frustrating.
I think a lot of our audience and us as individuals take the crimes of child sexual exploitation very, very seriously and find it to be a very serious crime that deserves a serious sentence to reflect how damaging this sort of crime is. And when you have somebody potentially getting a much easier sentence just because of a technicality as far as Indiana not recognizing the seriousness of this crime quick enough, that's pretty, I imagine a lot of people are going to be not so happy to hear something like that.
Yeah, it's frankly upsetting. And usually when something like this happens, you want to be able to say, oh, the legislature should change it. But as I say, they did change it.
In fairness, yeah.
They just didn't change it quickly enough to apply to Kegan Kline. And of course, as a matter of justice and public policy, you're not allowed to charge people with laws that did not exist at the time the crimes were committed.
I know the answer to this, but why is that?
Basically, it's just not fair. It creates the possibility for a huge abuse of power. You want people to have notice. These particular acts are illegal. This is what would happen if you commit them. And let's say you don't like a hat I like to wear, and I wear it out to dinner. You don't have the right to go home and write a new law saying, if you wear that hat to dinner, I get to shoot you.
Are you seriously relitigating the straw boater incident? No, I'm just kidding. We've all been in arguments like that, I'm sure, where, you felt someone was being unreasonable because they're springing some, something on you at a later date that you may have not realized was problematic. And then you kind of have to, deal with that. But just from a legal perspective, add going to prison on that. And it sort of makes sense that you can't just, that would be pretty, if suddenly the mayor of Indianapolis outlawed wearing blue, and there's a picture of you on Facebook wearing a blue shirt, from 2014. That's a stupid example, but you know what I mean. So that's one of the kind of big wrinkles in this case that Prosecutor Kiefer is sort of getting at in this latest filing, basically noting that they sort of missed the window for classifying Kegan's crimes as violent just due to timing, just by a few months.
Now, Kegan is charged and pled guilty to a number of counts. Some of those counts were level 6 felonies. The Indiana Code says, if the most serious crime for which the defendant is to be sentenced is a level 6 felony, the total of the consecutive terms of imprisonment may not exceed 4 years. Now, Kegan was also charged with some level 5 felonies. Here's what the code says. If the most serious crime for which the defendant is sentenced is a level 5 felony, the total of the consecutive terms of imprisonment may not exceed 7 years. Now, let's talk about that. Basically, what that's doing is setting a limit on the total amount of time a person can serve for charges associated with a single episode of crime. Remember, I talked about going down to Walmart and stealing 3 boxes of cereal. If I go down to Walmart and do that today at 3 p.m.
Please don't.
That would count as a single episode. Now, let's say I go down to Walmart today at 3 p.m. I steal 1 box of cereal. A month from now, I go to Walmart and I steal another box of cereal. 3 months from now, I go down to Walmart and I steal another box of cereal. The end result is the same. I've stolen 3 boxes of cereal, but in one instance, it was all done at the same time as a single episode. And in another instance, it was done separately, so it's separate episodes. So the amount of time Kegan is likely to face is going to be based upon whether or not Judge Spahr classifies these 25 counts as 1 episode, 8 episodes, 20 episodes, or what have you. I know all of this can be very confusing, so let me try to boil it down to the basics in a way that's hopefully clear. Kegan faces sentencing on 25 counts. 12 of those counts are level 6 felonies, and 13 are level 5 felonies. A level 5 felony carries in Indiana a maximum sentence of 6 years in prison. A level 6 felony in Indiana carries a maximum sentence of 2.5 years in prison. So it would be theoretically possible for Kegan to receive the maximum sentence for all of those counts and have them be served concurrently. And if they're served concurrently, that means basically he would be serving 6 years on the level 5 and 2.5 years on the level 6. But it's also possible, according to Prosecutor Kiefer, for those sentences to be served consecutively, which would be one after the other. This would elongate the amount of time that Kegan spends in prison. But if Kegan is ordered to serve his sentences concurrently, the maximum sentence he receives will be based on how Judge Spahr chooses to bundle those 25 counts into specific criminal episodes. So what you need to keep in mind is no matter how many counts are included in a specific criminal episode, if the most serious count in that episode is a level 6 felony, then the maximum sentence Kegan could face for that episode is 4 years. No matter how many counts are included in a specific criminal episode, if the most serious count in that episode is a level 5 felony, then the maximum sentence Kegan would face for that episode would be 7 years. So what it boils down to is how many criminal episodes are contained in those 25 counts. And even Prosecutor Kiefer acknowledges that there are not 25 separate criminal episodes in those 25 counts. So the first thing Judge Spahr is going to need to figure out is how many criminal episodes are there in these counts. Now we're going to go through the counts. We're going to discuss Prosecutor Kiefer acknowledges in some cases that multiple counts really comprise only one episode. But in other times, she says, no, each count is a separate episode. Before we start doing that, I want to point out that the most difficult and confusing one here is that there are 10 counts relating to possession.
Of child sexual abuse materials. So those are counts 10 through 20.
And it's more difficult to figure out if possession charges are a single episode or multiple episodes.
Why?
Right now, I'm looking at a bookshelf with, say, 20 books. I possess all of those books now. If possessing each of those books is a separate crime, am I currently possessing all of those books as one episode? Or do you say, well, Kevin, actually, when you purchased the first book, you started committing the crime related to that. And when you purchased the second book, you started committing the crime separately, which is related to that possession, and so on. Mm-hmm. So defense attorney Aki can say, no, if he's possessing them all at one time.
The whole library is the problem, not each individual book.
Right.
And then the prosecution's going to say each individual book constitutes yet another specific episode.
And each episode began separately when the possession of each book began.
So it's
a confusing argument,
yeah.
But that's what's going to determine whether or not the possession count is one episode or multiple episodes.
Wow, it's going to be so complicated. And
it's complicated, and whenever I think about episodes and stuff of that, there was a case very early on in my career I encountered where a person owned, I believe, 12 horses, and he did not feed those horses. And those horses starved, and many of them passed away. And so he was charged with 12 counts of animal cruelty. And when it came time to sentence, the question was, were those 12 counts one episode or multiple episodes? And also it became confusing in that case because not feeding them was a non-act. So it's not as if this person was sitting in bed saying, okay, right now from 7 p.m. to 7:05 p.m., I'm not going to feed horse 1. From 7:05 p.m. to 7:10, I won't feed horse 2, and so on. And so ultimately that was found to be one episode.
Mm-hmm.
So it's very confusing.
Yeah. I think a lot of people kind of tend to think, almost like you're facing life in prison for a murder. It's this kind of like this one concrete, if you're guilty, then that's what you're going to get. And when you actually arrive at the moment of sentencing, there's a lot more, it's much more of a choreography and a complicated, set of arguments than it can appear, especially when you're having so many counts involved here.
Now, Prosecutor Kiefer basically says it does come down to which of these counts constitute how many different episodes. And she says the standard for determining whether or not different charges relate to one episode is whether or not the crimes outlined in the charges are closely related in time, place, or circumstance. So think of me again going to Walmart. If I go down to Walmart and I steal a bunch of things at one time, it's related in time, place, and circumstance.
And you're at Walmart in the cereal aisle. It's all happening at the same time, and the circumstances are you are obsessed with cereal and want to get it for free.
And if I'm doing that, if I steal one box today, one box a month from now, they're not closely related in time, even though they're happening at the same place.
And they're similar circumstances. So is she saying that all of those factors have to be present?
She's saying these are the factors you have to consider when you determine.
But that seems like there's a lot of room for interpretation.
In the law, there's always room for interpretation. Now, why don't you open up Kegan's counts, the counts that he pled guilty to?
Yes. I've got it open.
Okay. Read count 1.
Count 1, child solicitation.
Prosecutor Kiefer says that is itself a single episode. She says that offense is not closely related to time, place, or circumstance with any of the other crimes for which Kegan Kline has pled guilty.
Okay, so that's like a separate incident in her mind.
And she also specifies that, I'm quoting, this is the only count of child solicitation the defendant was convicted of and pertains to victim number 1, who is not involved in any other charges.
Okay. That seems like a pretty good argument for it being a separate episode.
Now, she also says that counts 2 and 3 each comprise their own separate episode. What are those two counts?
Count 2 is child exploitation, disseminate, exhibit, or offer to do so. And then count 3 is child exploitation with intent to arouse or satisfy the sexual desires of any. It cuts off there, but you get the picture.
Right. Prosecutor Kiefer, I'm quoting, count 2 arose from a conversation that occurred on April 30th, 2016 with Kik Messenger chat user person 3 and contained an image that was not disseminated in any of the other child exploitation offenses.
Okay.
Count 3 is its own episode of criminal conduct. This offense occurred on May 2nd, 2016 and arose from a conversation with Kik Messenger chat user person 2.
Right.
So she's saying these happened on different days, involved different people. So these first 3 counts should count as 3 separate episodes.
I mean, I'm not a lawyer, but that makes sense to me. I can understand why the law has to draw a line around these things and certainly prevent overly harsh prosecutors from throwing the book at people when that's not necessary. But at the same time, when you're saying these are different times, different circumstances involving different child sexual abuse materials, that's a pretty good argument for them being different episodes, in my opinion.
Prosecutor Kiefer writes, the state concedes that counts 4 through 7 comprise a single episode of conduct. What are counts 4 through 7?
Count 4 is child exploitation with intent to arouse or satisfy the sexual desires of any. Again, it cuts off. And then 5 through 7 are child exploitation, disseminate, exhibit, or offer to do so.
Here's what Prosecutor Kiefer says about that. Although these crimes involve CSAM of different victims, they all occurred on May 14, 2016, and during a conversation with Kik Messenger chat user person 1. Mm-hmm. These offenses are closely related in time, place, or circumstance, and occurred essentially simultaneously and contemporaneously with each other.
Yeah, that makes sense.
So she's conceding those multiple counts, but only one episode.
Right.
For the same reason, the state concedes that counts 8 and 9 also constitute a single episode. What were counts 8 and 9?
8 was child exploitation with intent to arouse or satisfy the sexual desires of any. And then 9 is child exploitation, disseminate, exhibit, or offer to do so.
And she writes that those two crimes occurred on May 17th, 2016, during a conversation with Kik Messenger chat user person 1. Now we have the possession counts, which we already kind of addressed.
Yeah, those are 10 through 20.
Counts 21 and 22.
21 is synthetic identity deception, knowingly obtains, possesses, transfer, uses. 22 is the same.
Prosecutor Kiefer writes, these are separate episodes of criminal conduct from each other and all other offenses in this case. These crimes involve the use of two different fake personas, and although there was overlap during the time the crimes occurred, they are not closely related in circumstance to any other crimes committed by the defendant. And so she makes the argument that 21 and 22 should both be considered separate episodes.
And our understanding is that at least one of those is related to the Anthony Schatz account where he stole the Alaskan state troopers / male models photographs to set up that account.
The state concedes that counts 23, 24, and 25 are a single episode of criminal conduct.
And those are all obstruction of justice, knowingly or intentionally in an official proceeding.
So that basically connects back to when Kegan basically hid a phone he'd been using to communicate with people and then deleted a bunch of data from that phone before turning it over to the authorities.
So that's one incident. He's not doing that multiple times with different phones on different dates. That's a single situation.
Right.
Yeah, it's a lot to think about, a lot to consider. So anyway, that's our look into the prosecution's latest filing in the Kegan Kline case. Hopefully that clarified some of the possibilities. There really are no answers to have at this point because we don't know what the defense is going to say and we don't know how Judge Spahr is going to ultimately rule on the sentencing. But at the very least, we're getting a sense of what Miami County wants. Hopefully this will just give us something to think about in the run-up to sentencing next week. In the meantime, we'll be continuing to cover this case and definitely let us know if you have questions.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.